welcome to a special installation, special episode, if you like, of the Law and Nature Dialogues, brought to you by the Centre for Environmental Law at Macquarie University Law School. Today, we are treated to a paper about ecocide, entitled Nature, the Unspoken Victim of Ecocide. Ecocide is a very novel topic, a very interesting cutting-edge topic in international and domestic environmental law currently. The scholarship is burgeoning, and I think we are very fortunate today to hear from a scholar who is at the forefront of this research. We're going to be hearing today from Fatima Iran Nejad Parisi. She is a PhD candidate at the Faculty of Law and Political Sciences at Allama Tabatabai University in Tehran. She's also a visiting scholar at the University of Technology, Sydney. The discussant for today, complementing Fatima's paper presentation on ecocide, is Asanka Ediri Singer, who is a PhD student at Macquarie University School of Law. Ecocide, as I mentioned, is a burgeoning topic in both international and domestic environmental law. Fatima today is going to explain to us that whilst the Rome Statute, the Statute of Rome, which is the seminal legal instrument for international criminal law, does include some references to environmental destruction, this instrument is one that has been conceived and applied to situations involving conflict, situations involving wartime. But as Fatima is going to explain to us today, most environmental harm happens in a period of peace. So how can the Rome Statute and international criminal law generally, how can this be reconciled with this ongoing destruction, if you like, of the environment and the occurrence of ecocide? I'll pass over now to Fatima to give her paper on Nature, the Unspoken Victim of Ecocide.
Thank you. The Russian invasion of Ukraine is affecting not only the people, but also flora and fauna in the region. I expressed my solidarity with Ukrainian people, and my hope is for peace, equality, and justice for them. My deepest thanks are owed to Professor Janet Blake, Professor Anna Roljak, and Professor Ben Boer, who have given me constant support, and this presentation would not be possible without their engagement and intellectual exchange with them. Furthermore, I want to thank Professor Suryadeva and the center that gave me the opportunity to talk with you today. Welcome all participants here face-to-face and online. Today, I'm going to talk about nature, the victim of ecocide, which is silent and unspoken. The consequences of spraying the jungles of Vietnam with Agent Orange by the United States not only resulted in the poisoning of many fighters and caused a refugee crisis, but also caused the defoliation of approximately 5 million hectares of Vietnam's forest. American scientist Arthur Galston, as a response to denounce the destruction of plants on a larger scale and misuse of science to destroy the ecosystem, coined the term ecocide to describe the practice of using the herbicidal warfare program known as Operational Ranch Hand. In his opinion, the deliberate and lasting destruction of the environment that people can choosing to live in it should be similarly be regarded as a crime against humanity, and such an act should be called ecocide. Following this, a draft international convention on the crime of ecocide was prepared for United Nations consideration, which primarily envisaged ecocide as a military offense that could be committed in times of war and peace, which was never adopted. In another international effort addressing the effectiveness of genocide convention, ecocide was considered as a missing method of genocide to be included in that convention, which never happened. Later, ecocide was included in draft code of crime against the peace and security of mankind, but similarly, this was eventually moved entirely. This international endurance to identify ecocide, whether as a method of genocide or as a crime against humanity, were mostly focused on the ecological dependence of humans on nature around them and indirect destruction of environmental change or environmental harm that can disrupt socio-ecological relationships between humans and nature that are imperative to the social, cultural, spiritual, and physical health of a particular group of people. In this context, protection of human rights is paramount, and this includes protections pertaining to one's living environment. However, this anthropocentric perspective is too restrictive, as it does not address those activities that may even greater impact on the natural world, which may not be directly affecting human beings. On the other hand, paying attention to the harm-defining process in which both humans and nature bear the costs of devastating consequences of ecological harm in times of peace, it has been recognized that ecocide often occurs simply as a consequence of human economic development in times of peace, rather than being a result of a predetermined, intended direct attack on the environment. Accordingly, it has been used as a term to refer to the destruction of ecosystems and species they support on a broad scale, which conceptualized ecocide as a new international crime against the environment and give precedence to nature as the very direct and silent victim of ecocide, which imply that harm to non-human natural components itself as a result of both legal and illegal activities mostly happens under the cover of economic growth. In this context, threats to nature itself are closely aligned to the concept of ecocentrism. Ecocentrism refers to viewing the environment as having value for its own sake, apart from any instrumental and utilitarian value to humans. Thereby, conceptualization of ecocide in an ecocentric approach considers this crime as a legal tool to protect the environment based on whether the notion of rights of nature or duty to protect nature, or a combination of them, can be conceptualized as ecocide to punish all entities, including nation states and transnational corporations, where cases should be able to be brought to the court on behalf of entities such as rivers, forests, mountains, and birds, if they are affected by ecocide-related acts and emissions. In this context, taking into account the cross-border and transnational nature of several natural components and international dimension of Earth process changes, and some universal ecological crises such as climate change, ozone depletion, and global warming, show that ecocide is not limited to a geographical region or a specific zones, and render the call for the possibility of considering ecocide as a transboundary and multi-jurisdictional crime against nature, which necessitates criminalizing it at international level. This raises the question of how inanimate natural components such as oceans, atmosphere, climate, and natural beings beyond humans, both flora and fauna, can be recognized as victims. In fact, in order to prosecute in criminal acts and assess penalties, including the performance of restorative acts to the harmed ecosystem or any other natural beings, we require to define the victims and the harm or loss suffered. In this regard, the 1985 United Nations General Assembly Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power defines victims as persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omissions that are in violation of criminal laws operative within member states. According to this instrument, a key and fundamental criteria to identifying victims is their legal personhood. In other words, victims are confined to a group who are recognized as persons. The next step to identify a person as the victim is finding the way they have been affected by the crime. In this regard, the definition of victim in this declaration recognizes two methods. One is based on the question of who was suffered from harm, directly or indirectly, and the other is based on the question of whose rights have been violated. This kind of defining the victim is mainly based on an anthropocentric approach relevant to the historical context. The foundational ground of genocide and enslavement as the clearest and most known forms of inhumanity originates in the denial of this fact that other entities, including outsiders, minority groups, as well as other animals and inanimate natural components, potentially have the capacity to enjoy the legally protected right or interest, or recognizing the very pseudo-rationalization that those who suffer from harm have less dignity and intrinsic value than those entities who are worthy of being respected and protected under the flags of humans or legal persons. This clearly shows that while United Nations General Assembly took a human-centric approach to define victims of a crime in a way that it assumes suffered harm or violation of rights would pertain only to persons or humans. Taking an ecocentric approach towards an ecocentric perspective to ecocide raises the question of how we can extend the notion of victim to non-human world. In this regard, although ecocide may result in devastating consequences to nature, as well as to humans, non-human beings and inanimate natural components or nature as a whole is not traditionally considered to be a holder of legally protected rights or interests in a global scale. Furthermore, legal personhood for such elements is not recognized at international level. However, Rome Statute's Article 8, Part 2b4 on war crimes holds a perpetrator responsible for environmental damage, however, limited to the wartime situations and to intentional damage. I believe that it gives us the answer since it reflects this fact that Article 8 indirectly implies that natural environment as a whole is recognized as a legal person whose, according to the harm method, the offending act may involve widespread, long-lasting, or severe harm to it as a victim. The next discussion I'm going to talk about is the threshold of criminalizing ecocide. On the other hand, criminal responsibility has two pillars: a physical element, such as an act or omission that has resulted in the commission of a crime, and a mental element. Under an ecocentric approach, the definitions of ecocide include various thresholds, both for the mental and physical elements of responsibility. Although many acts and omissions take place that result in harm or suffering for non-human animals or any other inanimate natural components, but the degree, acceptability, or even necessity of the harm is viewed by many as justifiable. This is why the thresholds of physical element for ecocide almost in all proposals contain indicators of environmental threats and damage, namely the size, duration, and the impact of the extensive damage to degradation of nature, which can result in reparable damage or restoration for that situation will not be possible, but in long term. On the other hand, in some cases, environmental degradation has happened based on a previous intent, such as that in the case of use of defoliants, for example, Agent Orange in the Vietnam War, and the blowing up of oil wells and subsequent pollution during the first Gulf War in Iraq and Kuwait. But sometimes it takes place as a result of reckless events, such as consequences of reckless management of nuclear power facilities or oil spills, such as the 2010 Deepwater Horizon oil spill in the Gulf of Mexico. This is why different proposals of criminal ecological responsibility is typically defined on a spectrum ranging from strict liability to broader responsibility perspectives. All these differences require us to understand the right meaning of ecocide and precise understanding of its elements. Although there have been some developments about ecocide in recent years, I will be focused on the definition of ecocide proposed in June 2021 by the independent expert panel for the legal definition of ecocide convened by the Stop Ecocide Foundation, which is of special significance as the most recent effort to propose amendment of the Article 8 of Rome Statute. In this regard, I will address if the proposed definition by the expert panel conveys the right meaning of ecocide from an ecocentric perspective. The first question I'm going to discuss and address is of what constitutes the mental element of ecocide. Defining the mental element of criminal responsibility is crucial for determining the scope of criminal responsibility for a particular crime. Accordingly, the definition of the mental element of liability is of particular importance in international criminal law. where not only international criminal court's task is limited to the most serious crimes of international high-level perpetrators, but also evidence is hard to collect. And the link between the crime and high-level perpetrators is often opaque. In this regard, Article 30 of the International Criminal Court Statute sets a general rule for establishing the mental element of criminal responsibility that is applicable to all crimes subject to the court's jurisdiction. Article 30 stipulates that unless otherwise provided, a person should bear criminal responsibility if the material elements of the crime were committed with intent and knowledge, where knowledge is mostly defined as awareness that a circumstance exists or a consequence will occur in the ordinary course of events. However, taking into account the fact that environmental harm is often anticipated but not necessarily intended or known, which certainly reflects that to deter environmental harmful activities and to prosecute the cases relevant to ecocide requires a lower level of mental element than the default rule provided under Article 30 of Rome Statute. As a result, it raises the question of could we apply a lower level of mental element than the rule that is generally applied to other international crimes? And if yes, how? In this regard, it's noteworthy that the Rome Statute recognizes the possibility of applying a lower level of mental element in specific situations at the International Criminal Court. A clear example of this is Article 28, Part A, which criminalizes negligent omissions by military commanders which have led to the commission of crimes by their subordinates. According to legal definition of the crime of ecocide proposed by the independent expert panel in June 2021, ecocide means lawful or wanton acts committed with knowledge that there is substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. In this manner, the expert panel has attempted to expand the scope of liability for ecocide compared to the default Rome Statute mental element requirement, and by using the term knowledge in the proposed statutory text. The expert panel recognized that the crime may often be committed with reckless disregard for the environment rather than a concrete intent to harm it, but ambiguously relied on the term knowledge of the crimes in the actual definition. The first paragraph of the text requires evidence of the accused's knowledge that there is a substantial likelihood that their actions would cause severe and either widespread or long-term environmental harm. However, in the commentary to the text, the expert panel suggests that their understanding of the mental element of liability for ecocide is closer to recklessness or dolus eventualis. With respect to the ensuing environmental harm, legal experts quickly pointed out the conceptual ambiguity of the mental element of ecocide proposed by the expert panel and noted that all three elements, knowledge, recklessness, and dolus eventualis, in fact, pose very different requirements. In fact, implying recklessness or dolus eventualis in practice, the definition of ecocide fails to provide clarity about the scope of the criminalized conduct. Thereby, the way in which this task has been accomplished in the proposed text of Article 8 is likely to cause important interpretative challenges if adopted. The next question is, what are the physical elements of ecocide? With respect to the applicable threshold of environmental harm, the independent expert panel has taken a mixed test influenced by the conjunctive test provided by Article 8 of Rome Statute and disjunctive test provided under ENMOD's definition of environmental harm. Accordingly, the expert panel offers a conjunctive and disjunctive test according to which ecocide includes environmental harm that is severe and either widespread or long-term. In the commentary to Article 8, the expert panel makes a convincing point for choosing this option. On the one hand, environmental harm always needs to be severe to be classified as ecocide. This reasoning makes sense, considering that the inclusion of the severe requirement as a compulsory element of Article 8 not only is consistent with the International Criminal Court's limited mandate, which focuses on the gravest crimes, but also, according to the explanation of the expert panel in the commentary, the strictly conjunctive test was unnecessarily high, and it would have ended up excluding certain conducts whose consequences might have been widespread but not long-term, and vice versa. Another significant contribution of the expert panel is providing detailed definitions of the three elements: severe, widespread, and long-term, since the scope and content of these terms are not included in the Rome Statute. This vagueness represents a challenge for the International Criminal Court prosecution in terms of determining what harm meets the damage threshold and merits the initiation of criminal proceedings. Severe means damage which involves very serious adverse changes, disruption, or harm to any element of the environment, including grave impacts on human life or natural, culture, and or economic resources. Widespread, in the proposed definition, means damage which extends beyond a limited geographic area, crosses state boundaries, or is suffered by an entire ecosystem or a species or a large number of human beings. And finally, long-term means damage which is irreversible or which cannot be redressed through natural recovery within a reasonable period of time. The definition of widespread recognizes that the term may relate not only to a large number of human beings, but also to entire ecosystems or species. Similarly, the severeness of ecocide is assessed with regard to the disruption or harm caused to any element of the environment. The expert panel's definition recognizes that widespread may refer not only to physical distance, but also to the spread of environmental harm across an entire ecosystem, thus addressing the complex dynamics of ecocide, which are progressively ecocentric. Thereby, the definition provided by the expert panel allows for considering as ecocide even those forms of environmental harm that do not directly affect human beings or that have not occurred in approximately 2 human communities. Overall, the proposed Article 8 brings important improvements compared to Article 8 of Rome Statute. The definition of ecocide applies to peacetime, provides a less demanding mixed conjunctive and disjunctive test for assessing environmental harm, and defines in detail the terms severe, widespread, and long-term by demonstrating sensitivity to the far-reaching consequences of environmental harm. We talked about the ecocentric perspective in the definition proposed by the expert panel. Here the question is that, can we find any anthropocentric aspect in this definition or not? The text of Article 8 specifies that the proposed provision can be applied only to unlawful or wanton acts that have caused severe and either widespread or long-term environmental harm. In this regard, the first alternative, unlawful acts, would be of limited use because, unfortunately, most environmentally harmful acts are lawful both at the international and the domestic level. Here, the term wanton was proposed to criminalize factor with respect to otherwise lawful acts. The scenarios covered by the second alternative, wanton acts, are of crucial importance for enforcing the proposed ecocide crime. Article 8 defines wanton as acts undertaken with reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated. Rather than inviting us to think about the complexity of human interactions with the environment, the definition of the wantonness element presents a simplified idea of a cost-benefit test. The way in which the definition is framed, namely to balance social and economic benefits with environmental harms, implies that humans are the ones to benefit and the environment is the one to suffer the costs of particular actions. I conclude that the cost-benefit test conveys the wrong message to the international public, that the problems of the environment and the problems of human communities can be separated, and that humans may, in some cases, legitimately benefit from the severe and or widespread or long-term degradation of the environment. However, in reality, both humans and the environment bear the costs of ecocide. So the abstract idea of balancing costs and benefits obfuscates the very different manner in which people across the globe experience those costs and benefits. The benefits of particular action, such as mining for rare metals to produce electronic devices, are far more likely to be felt in the global north, while the costs are felt in the global south. These considerations make an assessment of the wantonness of a particular conduct especially challenging. Thereby, the definition provided by the expert panel of the term incorporates considerations of the anthropocentric view in the definition of ecocide, which would lead to wrong legal implications for the ecological justice aimed in ecocide. Finally, the question is, who is responsible? After identifying the victims of ecocide, the causal link between the crime and harm must be determined and connected to perpetrators. In this regard, ecocide mostly occurs as a result of both legal and illegal action and emissions of natural and judicial persons, where there might be one dominant actor or there might be a combination of multiple actors. This issue raises some difficulties to answer the question of who should be prosecuted and finally charged with the crime. Furthermore, the complexity and ambiguity of proving causation results from the necessity of distinguishing natural consequences from human-made ones poses another practical challenge regarding what consequences should be attributed to the responsible party and what to the other natural processes. Regarding ecocide as the gravest and most serious environmental damage, in many ecocide cases, the devastating consequences are resulted from the action and emissions by people acting through corporations or other entities, including states. In fact, under our current neoliberal capitalist order, corporations and states are among the most powerful offenders who pose the most harm towards nature. This is not the whole story. Since states and corporations as the most powerful actors in international law frequently rejected the proposition that criminal definitions should apply to them. Based on this argument that a law imposing limits to the harm they cause would implicitly endanger the core values underpinning in economic development and therefore be damaging to the collective well-being. As a result, cases most likely would involve economically and politically powerful actors whose criminal responsibility has been rejected historically within the international legal order. However, the restrictive approach of international criminal court to confine the criminal responsibility under its jurisdiction to natural persons provided under Article 25, that means the court shall have jurisdiction over natural persons pursuant to this statute. Thus, given the significant contribution of corporate actors to global environmental problems, the inclusion of legal persons within the context of international criminal liability would provide an avenue to end to the de facto immunity which multinational corporations enjoy for the most serious environmental damage. I will end my presentation with a conclusion. Criminalizing ecocide will make it possible to bring cases to International Criminal Court on behalf of natural entities or species such as rivers, mountains, forests, and animals, if they are severely affected by acts and emissions. However, it's noteworthy that the purpose of any course of actions to protect the environment has two aspects. One is based on a proactive approach that means to prevent damage. And the other is based on the reactive approach that requires repairment of damage once it has happened. Although criminalizing ecocide under the jurisdiction of International Criminal Court can serve both retribution and deterrence, providing the requirements for the restoration of what has been lost is more significant than applying a punishment to the perpetrator. In some cases, the damage or serious disruption of ecological or natural processes may last for many years or be permanent, which makes plans for restoration to be hardly effective or even impossible. Furthermore, the court's ability to provide adequate corrective and reparative justice in a timely fashion is hampered by several factors, such as the length of time that victims wait to receive reparations. This means that complete restitution is likely to be impossible for nature in many cases. Thank you for your attention. I will give floor to Asanka for your discussion.
Thank you so much, Fatima, for your very insightful and very interesting presentation on the need of recognizing ecocide as a crime in international law against the environment, and also the urgency of recognizing nature as the direct, primary, as well as the voiceless victim of this crime. So I thought I'd discuss basic 4 points based on your presentation. The first one is the argument some people believe that the non-human beings are incapable of holding interests and rights. The second one is the link between ecocide and rights of nature. And the third one is the significance of your Fatima's conceptualization of ecocide in international law. And fourthly, I will talk a bit about attaining restorative justice through ecocide. So moving on to my first point, Fatima has highlighted that some people believe that nature is considered as incapable of holding rights and interests. And also nature is considered to have a lesser degree of dignity or inherent value. That is true. I think that is one of the main issues with our legal systems, the contemporary legal systems. It is not clear what the reason for this is, the exact reason, but somewhere along the line, we have adopted a differentiation, distinction between the human beings and non-human beings. And we attached a superior status to these human beings and an inferior status to non-human beings. Some people say that the root cause for this is religion. For example, Lynn White, he attributes the present environmental degradation to Christianity and says that Christianity in its Western form is the most anthropocentric religion that the world has seen. Or it could be the reason lies in the early philosophies, like, for example, Thomas Aquinas believed that non-human beings are irrational beings. And René Descartes, for example, he believed that animals are autonomous or machines. Whatever might have been the reason for this distinction, separation, hierarchical ordering of human and non-human beings, we cannot deny that this distinction is so deeply embedded in our legal frameworks today. That's why whenever we talk about rights of nature, interest of nature, legal personhood of nature, standing of nature before the courts of law, Some people think that it is illogical, it is irrational, and it is even laughable to think about such an approach. This is particularly visible in the responses to the early ideas on this matter, Christopher D. Stone's ideas and the dissenting opinion of Justice William O. Douglas in Mineral King case, and things like that. The impact of this distinction, I believe, is far more critical than what we often anticipate. Some of the scholars, they attribute the present environmental crisis to this distinction between man and the rest of the world, the rest of the nature. For example, Kuhns believes that the objectification and othering is the basis for all forms of violence. This is particularly relevant when it comes to the environmental protection. We see ourselves as the superior being, and we argue that everything should revolve around us, including our legal framework. We develop our legal system according to our worldviews, according to the way that we see the world. So according to the way that most of us see the world, we are the central concern of the environmental protection. But if we look at the other communities, for example, the indigenous communities, for them, nature is a sentient being, an agentic being, and sometimes they are inherently incapable of separating themselves from nature. The idea that we are different to nature is alien to them, foreign to them. For example, there is this Maori saying which says that I am the river and the river is me. So my argument is, while we see the idea of rights of nature laughable or irrational, it would not be for some people. So it all depends on the way we perceive the world. The unfortunate thing is that our worldview, the way that we see the world, is not good. The experience has shown that, the evidence has shown that our way of seeing the world, our way of governing the world is causing many problems, many issues. Therefore, it is imperative for us to now adopt a more ecocentric approach, or at least a less anthropocentric approach in the protection of the environment. So I think what Fatima suggested makes very much sense. Conceptualizing ecocide with an ecocentric approach, conceptualizing it as a crime against the environment. So with that, I will move on to my second point. In her presentation, Fatima conceptualized ecocide as a crime against the environment, not against our right to environment, not against people's entitlement to use the environment, not against the people's belief that everything around us is for us, but against the environment itself. Why should we look at the crime of ecocide in a non-anthropocentric approach? Why is it important? As Fatima pointed out, if we continue to look at environmental protection from an extreme anthropocentric viewpoint, we will not be able to see the damage that the human action is causing to the environment, but which is not directly posing an adverse impacts to us, the human beings. It will one day, but not right now. Then, what is the link of Fatima's conceptualization of ecocide to rights of nature? Rights of nature says that the nature must have inherent rights, separate from human beings. Rights of nature is recognized today in different jurisdictions, including India, Bangladesh, New Zealand, Ecuador, Bolivia, even in Australia to some extent. However, their approaches have so far been constitutional, civil law approaches, or creation of guardianships. But I haven't seen, at least I haven't seen, the attempts to link rights of nature to criminal law. And Fatima's approach provides a link to these two ends, to link rights of nature to ecocide. Whenever I talk about rights of nature, given rights to nature, one of the questions directed at me is, okay, that is a good concept, but how do you suggest adopting it in reality, enforcing it in reality? And I think Fatima's approach is one of the most comprehensive and best ways of achieving it in actual reality, giving actual value, the practice, the implementation to the rights of nature approach. Then, yes, so the third point, why ecocide, recognition of ecocide in an ecocentric approach is important in international law. Fatima pointed out one reason, that environmental harm cannot be confined within the territorial boundaries. I also believe that it has another importance because international law provides a guideline or reference point for the national laws to develop on. So if international law recognizes ecocide in an anthropocentric view, ecocide as a crime against the environment, then the national laws will be able to develop their laws in accordance with that. So that is also another point. Then moving on to the fourth point, I believe I accept that some of the environmental harm can never be rectified. Once it happens, it will be permanent and irreversible. But still, it is good if restorative justice could be attained through ecocide. The adoption of the concept of restorative justice in environmental destruction allows the offender or the wrongdoer to make amends as quickly as possible and to rejoin the earth community, repairing or healing this severed relationship. Hamilton holds that restorative justice can be utilized across a wide variety of offenses and a wide variety of victims, including the environment. However, restorative justice in environmental harm, attaining it can be a very intellectually challenging task because if environmental restoration is done inaccurately, it can do a greater harm to the environment even than the original damage. For instance, I would like to quote Bradshaw. He says, and I quote, "How often are repairs of everyday objects unsuccessful because the repairer does not understand what is wrong, or having understood what is wrong, fails to make their repair correctly. As a result, the repaired object either fails to work at all or fails again very quickly." So environmental restoration is something which must be done very carefully. First, the environmental harm must be precisely understood. We must understand precisely what is wrong. Then only we can put right and accurate actions to restore the environment back into its previous condition. So those are the points that I wanted to discuss based on Fatima's presentation. And I want to thank you, Fatima, for her very insightful view regarding ecocide and the need of adopting a more ecocentric approach now, at least now. And also I want to thank Professor Surya Deva as well as Center for Environmental Law for giving me this opportunity. Thank you so much.
Okay, that's good. Okay. Thank you, Asanka. Thank you, Fatima. First of all, Fatima for the presentation, Asanka for your response. Yeah, I think both contributions are fascinating and provoke some really fundamental questions about how ecocide, I think, conceptually and practically is going to be formulated in years to come. So we will have some questions now from anyone online. No? Okay. Yeah. Or if anyone's listening online and wants to contribute, please do so via Zoom. And anyone in the room as well. But I'll pass over now to Fatima to respond. Okay.
That was a wonderful presentation. Thank you for that. Like, my question is related to the reason for recognizing basically environmental destruction and ecocide, if I understood it correctly, as a crime, against it being considered within the civil law liability scheme. I mean, what advantage do we get if when we consider it as a crime or it to be within the jurisdiction of the International Criminal Code? What is the advantage that it gets?
Thank you for your question. It's really important that we understand why it's important to recognize ecocide at international level. Although I believe that recognizing ecocide even at international level doesn't end to ecocide both in peacetime and wartime. Something that's so important at international level that I discuss is understanding what are the mental and physical elements of the ecocide as a crime. Because when we are talking about an international crime, it comes with the most powerful punishment by the International Criminal Court, which we should be cautious about the legality of the crime and the principle of proportionality between punishment and the crime. The difference between the recognizing environmental destruction as a civil, like having civil liability towards environmental destruction or illegal exploitation of natural resources is that when we talk about the crime, mostly we are focused on the deterrence aspect of the criminal system, which we want to send a message to those perpetrators that please stop, otherwise it comes with legal implications for you, which I think maybe at international level at least, name and shame is one thing is so powerful at criminal responsibility. And we need to understand that, we know, for economic development, we have accepted some levels of environmental destruction. And I believe at international level, we have committed ecocide. If the extinction of some species is not ecocide, what's the other name for that?
Okay, thank you. Thank you, Padma, for the wonderful presentation. I have a question which is basically related to how to go about punishing this crime of ecocide. Now, of course, you suggested that Article 8 can be operationalized of the Rome Statute in order to fit in the crime of ecocide. First of all, I mean, is there a political appetite for bringing in the reforms needed for finalizing the crime of ecocide as a part of international criminal court? And the second question, I mean, would it not be, of course, at the risk of sounding anthropocentric, would it not be appropriate, or for that matter, easier to accommodate this crime of ecocide within the rubrics of crime against humanity, which is committed during the peaceful time? Because if we look at all the crimes, they have wartime nexus. So even if you look at the crimes against humanity, they too have wartime nexus. So now, I mean, in 2016, the prosecutor of the ICC came up with a policy paper where it said that the environmental destruction which happened in Vietnam, it could be prosecuted. It was looking to prosecute those kind of crimes. So while looking at that kind of proactive step from the prosecutor's office, and the idea was to prosecute them as crimes against humanity. So would it not be much easier to have ecocide or destruction of environment be considered an international crime in form of crime against humanity, rather than undertaking an entire, I mean, reform process, which of course would require a lot of political will and support from various stakeholders, and not to mention that ICC and Rome Statute already enjoys a bit of frown from the countries which are the most contributing to the environmental crimes, environmental damage and destruction.
I think about your two questions, we need to distinguish between two different things. The first is that we need to distinguish between crimes in wartime and crimes in peace, which you really mentioned about the crime against humanity, which is really, if we are going to know the right meaning of ecocide, we don't have it right now at international level. And what we are talking about within the Article 8 of Rome Statute is environmental harm with intention, with other requirements stipulated in this article for wartime. And that's it. The next question that you asked, it's really interesting that we know for understanding environmental destruction at international level, we have two policy papers by the International Criminal Court's Office of Prosecution. One was published in 2013 and another one in 2016 that some scholars just discussed them as a very progressive action by the office. But there is a very thin line between recognizing ecocide from an ecocentric perspective with a human-centric perspective. I believe that what the office mentioned in those policy papers, that both for starting the investigations and both for the assessment of the impact of the crimes under the jurisdiction of International Criminal Court, they pay attention to the environmental destruction or even illegal exploitation of natural resources. They all come with the effects on human beings. In this context, even we are looking at environmental destruction as a crime against, as you told, humanity. What does it mean? It means watching and articulating this crime as a crime against human beings, not against nature or other elements of nature. And it's very interesting to know that the expert panel, I think very progressively ecocentric in the notion of environment, about the notion of the environment, they mentioned that environment is not only the earth. They extended the notion of environment to outer space, which makes sense because when we are talking about nature as a whole, it means universe. It doesn't mean only earth. We cannot limit the meaning of nature to our planet, because otherwise in this manner we are looking at environment based on the human's thoughts, which is really so anthropocentric. Any other questions?
I have a question for you, Ahmed. Asalka, I think you might be able to contribute to this one as well. The question basically is the relationship between ecocide and genocide. Now, this relationship, you look at instances, as you mentioned, of deliberate destruction of environment in the times of conflict, and you mentioned the Vietnam War and the use of Agent Orange. Now, it's difficult to probably say that there was a genocidal element to that. It was a horrific war, obviously, but I don't think there was a genocidal element to it. But there is some instances, probably in colonial contexts, where we could now look back at what occurred in terms of environmental destruction. We could put the tag ecocide on it, but it was very closely linked to policies of genocide that happened here in Australia and it happened in North America as well. Instances where state-based policies, government policies, aimed at particular destruction of species, for instance, in North America, which was aimed at wiping out a race of people at the same time. So just going to your distinction between the anthropocentric basis for a particular formulation of ecocide, and the ecocentric formulation. Do you see that there's a possibility, though, where those two things are kind of can be really strongly linked? If we argue that humans are part of an ecosystem, and in some situations, then, if we sort of collapse that distinction between anthropocentric and ecocentric and collapse that into one, we will find that there are instances where ecocide and genocide are very much that as well. And so, I mean, is that, like, given your knowledge of the Rome Statute and everything else, is that sort of approach possible? Is it feasible, or not? And I think, example with your stuff, you're talking about, you know, historically, law projects a sort of cultural value. And in Western law, and I'm going to include international law and Western law, all law is built around the idea of the human subject and the environment as an object. But with this approach, that sort of collapses as well. And do you think that there is any benefit in looking at it that way, or not?
Asanka, would you like to start first, or I can answer?
You can go first.
All right. It's very wonderful, I think, reference to the link in, I think, one of the participants online, and it's, yeah,
This is,
you need to mute.
sorry. Yeah.
Thank you. Absolutely. I believe there is a link between looking at genocide and ecocide, because humans are part of nature. As we saw in the definition of the severe term in the proposed definition of ecocide by the independent expert panel, they even included the damage to an ecosystem or a large human population, which makes sense because humans are parts of nature. But as Asanka very good pointed out, that we just perceive ourselves separated from nature. And we should not forget, historically, there was a suggestion to include ecocide as a method of genocide for the revising the Genocide Convention, which was never happened. So yeah, there is a link, and in the policy papers by the International Criminal Court's Office of Prosecution, I think mostly they paid attention to the environmental destruction to initiate the investigation or even to assess the impact of crime. Mostly they were paying attention to the link between ecocide and environmental destruction as a form of genocide, because culture and nature are interlinked. And where culture is coming from, if we have no nature, we have no culture. And I think this is why around the world, when you see different regions with different natural elements have different cultures. So the diversity of the nature comes with the diversity of cultures.
Yeah, interesting. And also because genocide itself can be the loss of culture. It doesn't necessarily have to be the loss of humans themselves, it can be the loss of culture as well. That can be genocide.
Yeah, because we are cultural genocide,
Yeah,
exactly, because if we are wiping out the natural elements that give identity to a group of people and you remove it, so how they can find their identity again? This is something I believe is happening for forced replacement of many people around the world who are facing with environmental crises like floods, especially, and food scarce or any other things that is relevant with environment. When you look at culture, we see environment and nature very important.
Thank you.
I can build on what Padmini said. No nature, no culture. I will provide an example. I recently concluded my field work in Sri Lanka. In Sri Lanka, there is an indigenous community known as Banda people of Bangladesh. As a environmental conservation mechanism in 1980s, the government of Sri Lanka decided to name their traditional lands, the ancestral lands, as traditional reserve. And as a result, they were asked to go out and go outside of their territorial, like their traditional lands. They were forcefully ousted from their land. And these people said that now I am living in the two different worlds. The world that I used to live earlier and the world that I live in now. The world that I live in now is entirely alien to me. I don't know what this world is. My world is here in the jungle. And we also said that within 2 generations, the entire community will be gone because they will be integrated into the normal society. So as you said, of course, that's a form of genocide. We're not killing them, we're keeping their culture. So I think the solutions on separating and protecting human language, but integrating them and accepting that we are a part of it.
Another thing I would like to mention is that we should not forget that the difference between genocide as a crime within the Rome Statute and if ecocide be adopted is that the element of intention in mens rea, which is really required for committing genocide. But I think because ecocide is a crime of consequence, we don't need intention. This is why many scholars like Falk, for example, they believe that ecocide is a crime of strict liability. We don't need intention. And maybe just a very important distinguish between them is the mental element of intent, because as you know, for genocide, we need the intention. Which always, we don't see it in environmental destruction. It comes sometimes with recklessness or negligence.
Yeah, it's interesting because it's almost like it could be, if I understand you correctly, I mean, my knowledge of the mens rea elements isn't what it used to be. It's essentially a lower threshold to satisfy under what you said before, that reckless, something approaching like recklessness as opposed to intent.
Or knowledge, yeah, exactly.
Yeah. So that lower threshold would almost be, a lower threshold to satisfy genocide, as sort of by extension.
Yeah, genocide.
This is an ecocide, but there's always, if you can show there's genocidal consequences from ecocide, then effectively you're saying that the lower threshold for ecocide, gives rise to genocide. And I don't think that's anything. There's nothing tricky about that or wrong. It's just a fact, really. Destruction of environment will lead to certain cultural or other forms of genocide.
Exactly, and as Asanka referred to the replacement of indigenous peoples, we should remember that when many countries decided to determine some areas as protected areas, it came with consequences and very bad consequences for indigenous peoples, because they forced them in many countries from moving from those areas to other parts of cities, which was not their culture. And I think maybe in some cases, we can see the link between the very replacement of the indigenous peoples with wiping out their culture, which is really a sign that shows us the very deep interactions of indigenous people with nature.
Thanks, Fatima.
Thank you, everyone.
Oh, I just had one question.
Yeah, that's all right.
Really thank you forever. I was just wondering, like, thanks again for like the speech, is really illuminating. I feel like the clash between nature and humans almost mirrors away like the clash between the global north and the south. It's kind of how he's talking about how the global north is so much to the benefit of the environmental destruction, which comes to the harm of the global south. So do you think a shift towards a more ecocentric perspective in international law is possible when the anthropocentric view dominates the culture of the global?
We should pay attention to the fact that what is law? Law is a human-centric phenomenon, which really makes it hard when we are talking about rights of nature or ecocide from an ecocentric perspective. And I think the rights of nature movement is something that is trying to give a new life to international legal order, to see the environment as part of our community, because we historically just separated ourselves from nature. And it's why indigenous peoples, and I think Asanka knows very well in this area, this movement of rights of nature around the world, especially from Ecuador and Bolivia, is initiated by the indigenous peoples, because their worldview about their relationship with nature is not the worldview of Western culture that we see in the Western culture. We see nature as a property, which we don't have the notion of property in the indigenous people's culture, which is really important to pay attention. And I think, Asanka, any other reflection might be great from you.
I think we can so I think even though those currently dominated by the definition of nature, I think the world is willing to incorporate more, progressive resources of the environment, and that's a positive thing, because we are increasingly recognizing good things. I think there are at least 10 or 11 countries now recognizing the nature. So yeah.
And I think, as very well you mentioned, in Western culture, when we trace it back to the colonization, they separated some groups of people as having no dignity, and they justified colonization based on this argument that they have no intrinsic value, they don't have dignity. And even about the slaves, women, and animals. So it shows us, I think, that the notion of legal personhood, or even the area of rights, is just expanding in international law. Now we don't have slaves. Now women are recognized with their own rights, and I think it's not far away to know nature as its own rights as well.
Thank you.
Thank you, Steve. Any other questions? Thank you, everyone, in person and online.
That's right.
Thank you all.
Thank you again, Fatima and Asanka. Thank you again for everyone who has logged in and everyone who attended. an excellent conversation, I think, to round out two excellent presentations. Just a quick word for CEL. We have a workshop on the 27th of July coming up in conjunction with the Global Network on Human Rights and the Environment to be held at our city campus. And in October this year, we have another Law and Nature dialogue, similarly on the topic of ecocide, but a panel discussion, which will be chaired by Chief Justice Preston of the New South Wales Land and Environment Court. Again, thank you everyone for tuning in. Thank you for the presentations, and we'll see you all soon, hopefully.
Thank you, Paul.